welcome to this family law update. Every Wednesday at 2, PCD Club brings its audience of professional advisors fresh content from the private wealth sector. We haven't done a family law update for the last 6 months, and with COVID, all has changed in terms of relationships, private clients, the way people are living their lives. So we're going to bring you the latest trends from that sector with a panel of experts. We've got two audiences with us today. We've got some PCD members with us on Zoom. We've also got a live audience on YouTube. Both are encouraged to ask questions, put comments in the chat. I will bring them live to our panelists as we move through the discussion. We love to hear from you in terms of where you're watching from, what you think of the content, any questions and comments you have for our audience. After 50 minutes, we will cut the live stream link and we will have a bit of networking with our PCD members to close up the session and a live Q&A. So looking forward to a terrific hour ahead. And just to open us up onto this, into this topic, I'm going to invite the three family lawyers from the panel. We've got Izzy Walsh from Hall Brown, we've got Nina Lake from Howard Kennedy, and Emma Nash from Fletcher Day. I'm going to ask them the question, will London continue to be the divorce capital of the world? It's a position it's enjoyed, if you like, in recent times. Is there anything on the horizon that will impact or threaten this? Perhaps, Izzy Walsh, could you get us underway on that topic of London's eminence here in the divorce?
Well, I mean, it most certainly remains the divorce capital of the world. And there are various reasons. It's the principles that underpin the enormous awards that we see, which are sharing principles of anything built up over the marriage, no discrimination between breadwinner and homemaker, meeting the needs of the weaker economic party, and very generous spousal maintenance provision, which just doesn't exist, particularly in our European neighbours. I think two things to bear in mind. The first is Brexit. If anything, I would say that that's opened up the scope for claims and that it makes exposure to the British, or English rather, sorry, jurisdiction a big risk for European individuals. And the second thing I think we need to have an eye on is whether legislation which has been discussed, for example, imposing a maximum term on spousal maintenance, or indeed legislating for prenuptial and postnuptial agreements, actually comes onto the statute. There's no real sign of it at the moment, but it's always on the horizon.
Okay, thank you for that. Nina, do you have any thoughts or views on London's eminence as the divorce capital of the world?
Yeah, I mean, I second everything that Izzy's just said, really. I think she's made some really pertinent points. And I think that the system here has got a real reputation globally as being a fair system. I think there's a lot of other jurisdictions that people come from and say, well, actually, I think that the English system is fair. I think as well that when a country has a reputation of being the divorce capital of the world, and it's been quite a long-standing one and quite a strong one, I think that's quite a difficult reputation to shake. And even with the changes that are on the horizon that Izzy mentioned, I think that it will still take time for that reputation to kind of fall by the wayside, if it ever does. But I would agree that it certainly does currently still remain the divorce capital of the world. I don't see that changing drastically anytime soon.
Okay, thank you. And Emma, do you have anything to add on this topic of London's position?
Well, I'm certainly not disagreeing. I think Izzy makes a great point about Brexit, potentially opening that up even more. And I think one of the things that the pandemic has shown us is just how international we are, particularly London. You still need some connection here to have your divorce here. And we are a huge international hub. And I don't see that changing. I know we've had difficulties with the pandemic, but we're not one of these countries that's been able to sort of isolate ourselves. And we have huge international business, which creates huge international movement of families. So yeah, I think that also, just to reiterate again, that the the fairness point and the discretion. We have a huge amount of discretion for each individual case. We're not formulaic. We don't have a set time for spousal maintenance. I think that is incredibly attractive. And yes, whilst we've got to keep an eye on what changes may be coming up in the future, I think as long as we've got that, and as long as we've got the international community, I can't see that changing.
Okay, thank you. And Izzy, just to get into the discussion, there have been some notable cases recently involving international ultra-high net worth clients. What have we learned from them?
Well, I mean, I think it really just follows on from the points that we've been discussing. So firstly, the big risk, if you are the financially stronger person, of exposing yourself to this jurisdiction, because, as Emma said, the courts have an incredibly broad discretion. The English courts are not shy at all of stepping in if they think that there's been any unfairness. There's a recent decision in the case of Patanina, which it overturned an earlier decision, but gives her permission to make a financial claim here, even though she received a substantial award in the Russian courts following a Russian divorce. I think the other case is the case of Akhmedova, which was that litigation has been really going on since about 2013. An award in the sum of 453 million was made against the husband in 2017. And the wife is still trying to enforce that award, but the English courts have most recently joined her son, plus various other corporate and trust bodies, and made orders directly against them on the basis that the husband transferred assets to them in an attempt to undermine the wife's claim. So the fact is that the English court, it's not only that it has this full discretion, it also has a lot of tools at its disposal. We have very rigorous requirements about financial disclosure. Parties have to disclose their assets no matter where they are. If you don't comply, there can be very severe sanctions, including substantial financial penalties or even jail time. Secondly, the English courts have global reach, which, and this is what Akhmedova really highlights, that the court can make orders about assets no matter where they are. Of course, there are practical implications about enforcement, but the orders can be made. And then thirdly, the English courts can freeze assets and unwind transactions, as well as joining third parties, again, no matter where those assets are located. You have similar problems about enforcement, but as a starting point, these are really quite powerful tools, and they can make life extremely uncomfortable for somebody, even if they have made sure that they have very few connections with England and Wales.
Okay, thanks. And what about on the use of litigation funding? That's appeared in some cases recently. How should people think about that if they're financing litigation?
Well, so I mean, it's a tool which, as I'm sure that Emma and Nina would agree, it's been very valuable, and that it's been used for some time in the substantive family proceedings. So in order to get your award at the conclusion of divorce proceedings. But what we've seen more recently, and again, this recent decision in the case of Akhmedova, what that highlights is the use of commercial litigation funding in enforcing the award. And it's a much more serious issue, because you're talking about funders of the likes of Beresford, who are they have been used to taking on some very serious commercial risks when they're supporting litigation. And there's a major advantage for a claimant or for the receiving party, in that if they don't have funds available, it enables them to pursue their claim. But it's a bit of a poison chalice, because if you subscribe, if you sign up with litigation funders of that kind, who then they develop an interest in the outcome of the case, it means that you lose control over your litigation to some extent. And I think that in the Akhmedova decision, there must be a very big question mark over whether it was Tatiana Akhmedova's choice to go after her son, or whether that was really something that she was forced to do by the relationship with the litigation funders. So it's got advantages and disadvantages.
Is financing generally available through other sources? I mean, do you find that, for example, banks or others are willing to lend unsecured, or how many options are there for people looking for financing?
Dealing with Russian clients, I would say it's extremely hard. If you have a property in London or England that you can secure your lending against, and this again is in the substantive proceedings, then there's a good likelihood that you can get some funding. But if you are not resident in this jurisdiction, if you've got no real ties, no assets in this jurisdiction, it's very hard at that initial stage. In terms of commercial lending, it will really depend on what the award is, because you're then coming down to pure commercial litigation of pursuing a debt.
Okay, thanks. And for trustees looking at risk management, protecting the value in a structure over the long term, what advice would you give them from a family law perspective? They're setting up a new structure or looking at existing arrangements.
It's a very interesting question, because I think we're all being asked to do a lot more prenuptial agreements, a lot more postnuptial agreements, and really focus on how to protect people from exposure to this jurisdiction. And the first point, which has just got to be really pressed home, is that the English courts will look at trusts in a way that other jurisdictions often don't. And they will look at them in three ways, really. The first is they'll look very carefully to see whether or not it's a sham trust. So whether the assets have really been transferred to a trust or whether they're still available to the party. The second is whether the trust constitutes a resource which is available to one of the parties. There's a bit of a question mark about how the courts will approach that now. But then the third, which is a very powerful tool, is variation of a trust. So when you're a trustee setting up the structures, you have to be incredibly alert to the power of the English court and think, I would say, very carefully about what jurisdiction you're looking at to set the trust up. Because a lot of jurisdictions now do have firewall legislation, which is really intended to prevent the variation of trusts, for example, or orders being made against trustees. But it doesn't always stop the court from making orders. So whilst if there's firewall legislation in place, I think the court is more reluctant to make orders, they will nonetheless make those orders if they think that it can exert pressure in other ways. So what I would say to trustees in that situation is, if you contemplate a problem, so the minute that you get wind of any problem, get specific expert family law advice.
Okay, terrific. Well, thank you for that, Izzy. That's a great way to get us off and running with this discussion. Just want to bring in Faye Hall from Smith & Williamson. Good afternoon, Faye. So you're an expert on valuing businesses, and you often work with family lawyers because the valuation of a business is a contentious issue. It needs to be properly established. So perhaps you could just explain a little bit about, in a divorce context, how you work valuing UK companies.
Yeah, thanks. It depends really how I'm instructed. So in the family law context, I more often than not instructed as a single joint expert. So kind of puts you in a bit of a difficult position in the fact that obviously I'm acting on behalf of the court, but ultimately I'm not acting for one party or the other. So I haven't got immediate access to the information which I need to value a company. And it's also apparent in these matters that there is usually one party who's far more knowledgeable than the other, i.e. they're in the business, they're working in the business. So therefore they've got access to the information and they understand, or they've got a better feeling of what they think the business is worth. The issue in valuations for divorce is that one party may have an inflated and often, high expectation of what that value may be, and the other one is very keen to underplay the value for obvious reasons. I mean, this is likely to be a sizable asset between the parties for divorce purposes. So from my perspective, it really is gathering as much information as possible and liaising with both sets of solicitors to get that information, and also then to actually write about and report on why I think the value is what I think it is, and to try and educate the court and make the parties understand that what I'm trying to provide is my opinion of what the business could be sold for, which is often not what the parties think that the value is. So that's what the court wants to know. The court wants to know, or ultimately wants a figure to put into an asset schedule, so that it can then decide, between the parties, who has what. And then it's a case of, can the business itself facilitate a settlement between the parties, which is another issue that I'm often asked to look at.
Thank you. And what's the impact of COVID been? Obviously hit some sectors harder than others, but is the view that it's a bump in the road in terms of valuations, or is there an element of some permanent impairment? What's your view been so far?
If you'd asked me that question about 10 months ago, my answer would have been very different. At the start of this, I thought it was going to be quite a large impact. Strangely enough, the businesses that I'm seeing in a divorce context, and those that I'm actually being asked to value and have been asked to value in the last year, haven't suffered anywhere near as much as I thought. Now, that is by reference to the type of industry I'm dealing with, and I've been back through some cases to kind of look at why that may be. And for example, you've got property companies. I don't think there's been a great impact as a result of COVID. And then there are those companies that have actually done quite well out of it. So I've considered companies in the pet industry, actually seen a mini boom. There have been bicycle companies, drink companies, which you might think that, as suppliers to pubs, they would have, really, really suffered. But actually, companies have been really resourceful. They found an alternative route to market. They've sold far more to supermarkets and other people than they have to actual pubs. So, they've actually managed to diversify, and also they've managed to save money, employment costs, marketing, business development, advertising. So it's not as bad as it could have been.
And how do you try and bridge that asymmetry between the business owner that's maybe trying to play down the valuation, but they know in the future there's a lucrative contract on the time horizon or something? I mean, I imagine this asymmetry is different from a corporate finance deal where you're trying to get the best price, you're trying to display, the value that's in the business. Is it about combing through all the paperwork and looking forward, as well as looking at the conservative value on the position of the company as it stands on the balance sheet?
Yes, as a forensic accountant, and as a forensic accountant for many years, we all come with a certain amount of cynicism, I think. So there is always, it's all about in the information gathering process and asking the right questions. And for example, if you take COVID, for example, as an example of this, people will be, my expectation was people were going to say, oh, the business has fallen off a cliff or whatever, and it's performing really badly. However, in such circumstances, you would then say, right, but you've applied for a COVID loan, and therefore there is an expectation, for example, that your company will continue trading in the future. You haven't wound it up. You're trying to save costs. You're trying to cut your cloth. And I appreciate this year is a bad year, but therefore this year is probably a blip in those circumstances. And going forward, you have an expectation as a business owner, I'd be saying, to actually get back to where you were before. So it's taking a view really on what information you can gather, and trying to be as reasonable as possible.
And we discussed with Izzy there the interaction with offshore trustees. I mean, how might you interact with professionals in other jurisdictions around a divorce case in the UK?
We try. We can only try. I mean, we have a network of offices overseas, and we can try and gather information. I find trusts actually quite difficult in the fact that they're often can be a brick wall in terms of information gathering. So if a trust itself owns a company, trying to get information out, or and the company, you might be able to value the company, but you don't know what else is in the trust. So if I'm being asked to value a trust, it's actually rather difficult. But again, you can only ask for the information, and if I'm not provided with the information, we have to take a view and caveat any opinion, unfortunately.
Okay, many thanks for that, Faye. If you have any questions from our audience for either Izzy or Faye as we move through, do put them in the comments, and I will bring them back on to discuss. But I'd like to bring in Sally Beresford from Tilney in Manchester. Good afternoon, Sally.
Hello, good afternoon.
So we were talking there with Faye about the valuation of business assets, but the UK pension is also a really important asset in terms of many UK divorces. But valuing pension schemes, the scheme benefits vary widely. Understanding what the scheme benefits are is very important in the process. So how might you help family lawyers understand what the pension means for a client?
Yeah, absolutely. Obviously, pensions are sometimes very complex, they're varied. So scheme rules are different from scheme to scheme, different types of pensions. They'll have different options on retirement. Some may have guarantees, some may have different levels of tax-free cash. Some will have different death benefits. So my role really is to gather all the information relevant to the parties, to really understand what that scheme benefit is and what it will provide to a client, and perhaps when it would provide that to a client. If we are requesting information on defined benefit schemes, then the scheme trustees will calculate the cash equivalent value that we'll use, but we'll kind of look under the bonnet and see what that actually means in real terms.
Because new defined benefit schemes they're less common, but they're still out there and highly valuable, aren't they? And the income stream being guaranteed in these investment markets is something that shouldn't be given away lightly.
Absolutely. It'd be rare really to find a new, somebody entering a new defined benefit scheme now. But people have pensions in place for years and years and don't really think about them. They just contribute to them, don't really understand what's going on, what income it will provide. So gathering the pension information is very important. It's often quite eye-opening as well to see what that's actually worth to a client.
Absolutely. Perhaps you could tell us a little bit more about pension sharing orders and how they're brought about and how they relate to divorce proceedings.
Yeah, well, the pension sharing order has to be issued by a court. It aims to provide a clean break between the spouses. So to share pensions allows an ex-spouse to take their share of that pension, perhaps out of the original member's scheme, out into their own pension. Schemes will provide different options. So some schemes will allow you to have what's called an internal transfer. So they'll allow the ex-spouse to become a member of the original member's scheme. Some schemes will say you have to transfer out. Other schemes will say we'll give you an option. It's quite rare really for schemes to say we'll let you decide whether you want to transfer out or take an internal transfer. But the role of a financial planner there is to really advise on, once we've been given the pension sharing order, how that should be implemented for a client. So for example, a case I've worked on in the last year or two, the client had a pension sharing order over 7 different pensions, 2 defined benefit schemes, the rest were defined contribution schemes, and both of the defined benefit schemes quite unusually said you can either have an internal transfer or you can transfer out. So there's a big piece of work there really with the client, firstly on educating her in terms of what a pension actually is, what it does, how we can use them, and then the advice on what should transfer. If it's transferring, where should it transfer to, how then should it be invested, understanding of then how you can draw your benefits from the pension. So a big piece of work and a lot of education really around what different pension schemes can provide.
And for high net worth clients coming up against the lifetime allowance, if they're then sharing this pension on divorce, there's follow-on implications for that. Perhaps you could explain a little bit about how that interaction might work.
Yeah, absolutely. So standard lifetime allowance now is £1,073,100, and we know it's now going to be fixed until the 2026 tax year. There are different rules from years gone by that allow you to have what's called transitional protection to give yourself a different lifetime allowance. So where one party might have pension benefits, I'm working on a case at the moment, one party's got pension benefits at 2.2 million and fixed protection at 1.5. And the other party has no lifetime allowance protection and their own pension benefits are valued around 200,000. So we would look then at how is best really to share the pensions to take into account the lifetime allowance so that the parties are treated fairly. So for example, if the party with fixed protection at 1.5 kind of shared or split a big chunk of their pensions, their pension value remaining would fall well below the 1.5 million, and they've got no lifetime allowance issues, but they've pushed the problem onto the other party who's got no protection, can't register for protection, and ultimately will end up paying a lifetime allowance tax charge. So part of the role of a financial planner is to look at the pensions alongside their other assets and try and come up with a more suitable arrangement whereby we can try and manage this lifetime allowance tax charge in a better way.
Okay, thanks. And a big question, I guess, from the financial planning side is if a client's going to be given a capital lump sum that needs to be producing income for the rest of their lives, at current, interest rates and macroeconomic picture, you're going to be able to provide some input as to what's a realistic amount of income that can be derived. So in that light, how do you support family lawyers in trying to understand how much of a capital lump sum will pay a reasonable income? And, if in court, the Duxbury tables are something that family lawyers will refer to, or the courts refer to, how do you see that all sitting together in terms of how you work out what kind of level of capital people need in order to produce an income?
Yeah, I think the Duxbury tables, whilst they're a good kind of starting point and used as a guide, they're not client specific. I think everybody on here would probably agree that they don't really work well in practice and they can lead to some unfairness. We would tend to look at cash flow modelling tools instead, where we can be very client specific in terms of their attitude to risk, the mortality, their needs and the fairness as well. So we use cash flow modelling tools. We can use those alongside family lawyers at the negotiation stages to really plot out and show what that capital lump sum in practice will provide, and provide a nice chart and a graph, and we can sit with the client with the tool in front of us and show this live and make some changes to scenarios. So it's very much a better way at looking at what a client's financial future will actually look like, rather than looking at a Duxbury table. The assumptions that the Duxbury tables make in terms of income and capital really would mean that a client needs to take quite a high level of risk, which is not relevant to most clients, particularly that cash interest rates are, well, virtually zero, and they don't take into account things like management charges. So the cash flow modelling tool is far more specific and far more relevant, I would say, than relying on a Duxbury table.
Okay, perfect. We've got a question from Nick Arnold. I'm going to put to Izzy first, I think. Just asking on enforcement. Nick's asking, please could you provide further thoughts on the impact the ease of enforcement has on agreeing a final settlement. If the large percentage of wealth is hard to enforce transfer on, might one settle a lower amount that could easily be secured, or one wouldn't settle? So like in the negotiation, if you know there's assets to get more easily, does it colour the way you approach a negotiation? I mean, Izzy, perhaps you have some thoughts on that question from Nick.
Most definitely. I mean, I think as a matter of tactics, you have to be really alert to what you can easily get your hands on, and that there can be a great kind of tendency to fight for an award. I mean, going back to the Ahmedova case, perfect example. You get one of the largest awards reported ever, 453 million, and then 4 years later, you're still pursuing it because you haven't had a penny. You probably owe your your funders an awful lot, and it is possible. I don't know in that case, but it's very possible that there would have been a situation where a deal could have been done on the basis of receiving, albeit a much smaller proportion of the assets, immediately available assets. And I've had cases where, again involving Russians, the wife, who was my client, was very aware that she had no idea of what the assets were, but she knew they were very substantial because of the monthly payments she got. But she just said, I am not interested. What I want to know is that the assets that he is giving me are here on the day I sign the agreement, the consent order, so that that's in the bag. I don't have to think about it again. There have been other cases. There was Michelle Young was another example of an award that she chased around the courts for years, and as far as I'm aware, never really got anything. So it can be a real, it's just a Pyrrhic victory to get an award on paper, and a real tough job of enforcing it.
Nina, do you have a perspective on that question on enforcement and the strategy you might employ to actually secure some real assets for a party?
Yeah, I think you've got to be realistic and look very closely at assets that are available, because enforcement can always be a very tricky thing to do, especially with international clients, especially when assets are spread across the globe. And I think that whenever a settlement is reached in the first instance, we're often having to be mindful of where assets are and the likelihood of enforceability. I've had cases before where clients have come to me and they absolutely have a very strong case in very high net worth families to get a substantial judgment. But the reality is that enforcement could be impossible, particularly when assets have been sort of in the Middle East, in Russia. There's certain jurisdictions it's very difficult to bring enforcement action against. So I think we do have to be mindful at the point of settlement or at the point of final orders as to where the assets are, and also when it does come to enforcement, take a view at times. That's not to say that you should just give up and that there's no hope in hell, but it's something we have to be aware of and conscious of. It's something we have to advise clients in relation to.
Okay, thanks, Nina. And just switching tack there and staying with you, it would be good to find out some more about people who've experienced a drop of income in COVID. You know, are those people coming back to court now on historic settlements? Under what circumstances are orders being changed in your experience?
Yeah, so I think we're finding that cases really turn on their own facts. So the courts certainly haven't ruled out varying previous orders due to the COVID-19 pandemic, but at the same time, it's not a slam dunk argument. And when we're looking at income specifically and payments of spousal maintenance, the applicant has to show that they've had a really significant change in their circumstances, and they have to evidence that. They can't just make broad assertions. We saw a case, FRB and DCA, back in 2020, where it was found that there were just sweeping statements made and no firm evidence to show that there had been a real significant change in circumstances there. So an award to vary down in the amount of maintenance was not given. The court has really broad discretion when deciding maintenance variation applications, and I think, as always, children are at the forefront of the court's mind and how any variation in maintenance would impact a child. We're also seeing other cases to vary previous orders that are not just in relation to income, so not just people's income dropping. We've found sort of through the COVID-19 pandemic, there's been various cases that have brought to court where people have claimed that their circumstances have changed so significantly because of COVID that they've been severely economically disadvantaged because of it. And there's a principle called the BARDA principle, which is a principle that existed pre-COVID. And it essentially said that a court can revisit a previous order if there's been some sort of unforeseen and unforeseeable event. So that event, so when COVID happened, I think family lawyers all thought, well, there's going to be a real floodgate opening for BARDA claims here, because who could have foreseen the COVID pandemic had such a severe impact on a lot of people's businesses and finances generally. And in order to satisfy that BARDA principle, there's quite strict requirements. So this unforeseen or unforeseeable event must really invalidate the basis on which the previous order had been made. The application, the event has to be made fairly soon after the order had been made, so months as opposed to years. So, you know, where orders had been made 5 years ago, you couldn't rely on the BARDA principle when COVID hit. the person applying under the BARDA principle has to apply so promptly, and any outcome that the court decides to make in revisiting the original order can't prejudice any third parties who have in good faith perhaps acquired property or assets which are the subject of the discussion. Again, in that situation, specific evidence needs to be provided showing that that individual has been economically disadvantaged, and firm evidence needs to be put forward. I referred to the case previously, FRB and DCA, where that wasn't satisfied. In another case, HW and WW, the COVID, the husband had claimed that COVID pandemic had impacted his global commercial printer and software company so severely that he shouldn't have to pay his ex-wife various lump sum payments that had been previously ordered. But in that case, interestingly, the judge said that in principle, yes, you know, the BARDA principle and revisiting the previous order could be relied on, but disagreed to do so in this case because he said that the impact at the time that the order was made, which was in March 2020, and because the husband was quite a savvy businessman, he said that the impact of the COVID-19 pandemic was foreseeable, so it didn't satisfy that requirement of being an unforeseeable event. And the judge also mentioned in that case that he felt that the husband's business would bounce back post-COVID. So even though there was a question as to when these lump sum payments were made, it was not agreed that they should not be made.
Okay, thank you, Nina. And with backlogs in the courts, I mean, what are the options for clients wanting to settle disputes privately?
Well, I think that mediation has, for several years now, become a really popular option for clients to reach out of court settlements, and that hasn't changed throughout the COVID pandemic. I think it remains a really popular method of out of court resolution. And I think mediators as well, like the rest of us, have adapted and brought their sessions online so that perhaps people can access mediators that are recommended to them that aren't just specifically in the location that they live, but perhaps in other parts of the country as well, which has been quite helpful. But I think the thing that we've really seen an uptick in as family lawyers is arbitration. Arbitration is sort of a more structured process of out of court negotiations. Both parties need to sign up to it, so both parties need to agree to go down the arbitration route. You then select your arbitrator, so you pick who you want as your arbitrator, and you'll pay a fee for your arbitrator, so it will be privately paid for. But in that setup, your client does manage the process to a much larger extent than they do with the court. So the parties can agree a timetable for the financial disclosure and for the scheduled arbitration sessions. And we can make sure that, for example, the dates that the arbitration happens are on dates that all parties and their barristers can attend. So you keep a lot more control over the process, and it can often move much more quickly than the court process might do. And I think the interesting thing with arbitration, where it differs to mediation, is an arbitration award is final. So the arbitration award that you get at the end, when a final decision is made, if you haven't been able to settle throughout the arbitration process, that is your final award. With mediation, you still need to take your agreement to lawyers, have that formalised into a consent order, and send it to court for approval. But I think arbitration has become a much more popular method of out of court negotiation and process.
FDR is part of that spectrum in terms of people less familiar with the jargon.
Yeah, so FDR hearings are in financial proceedings on divorce. There's three main hearings, and the FDR hearing is the second hearing in the proceedings. And essentially, that hearing is where all parties come to court, put forward their case, and the judge will give an indication as to the sorts of orders that would be made at a final hearing, and encourage the parties to go out and negotiate and settle. And a lot of cases, I think, previously would settle at that FDR hearing stage. But it's become very different, I think, during the past year, where people are no longer having to attend court and spend the whole day in a probably not so pleasant court setting trying to negotiate their case with a lot of pressure. I think that people are finding that sort of sitting at home without the pressures of courts and things, that the pressure's off a little bit. And so I've certainly seen that the court FDR hearings are not as effective. But private FDR hearings have been really successful. So a private FDR hearing is, in essence, the same concept as a court-ordered FDR hearing, but instead of going through the courts, you select your judge, if you like, who's often a very experienced barrister, and you will pay privately for them, but you select a date that everybody's available. Everybody's paid to be there, not that they haven't when they're in court because they've paid for their legal representation, but the parties have both agreed that they want to have an FDR, they've agreed on the FDR judge, and so in some senses I think people are slightly more invested in that. The courts also just have huge delays in listing court-ordered FDR hearings, so you might find a delay of 4 or 5 months between the first hearing and then the court-ordered FDR hearing, where a private FDR hearing is you can select your date, so you can move things forward. I think where judges have been having much heavier caseloads over this past year, we are finding, situations where you go to an FDR hearing all prepared and the judges have got so many other cases listed before them on that same day, they haven't necessarily had a chance to read all the papers, or they've had technical problems getting into the papers, and they may not have a full grasp on your case. And that can make them giving an opinion quite difficult. Whereas if you have a private FDR, you can guarantee that your judge has read all the papers and is also available. You're their only client for that entire day, so they'll be available all day to really assist you with your negotiations and come back on the calls and things to give opinions and make findings if you want them to. So there's some real benefits there, and I think that it's something that I would say wasn't used extensively before March 2020 and has become a real favourite for family lawyers and counsel in this past year.
Okay, well, many thanks for that. Emma Nash, just to come to you, I mean, it's been widely reported domestic violence being on the increase through COVID and lockdowns and all the pressures that brings on relationships. How is this being taken into account in the family law context?
Yes, well, the pandemic certainly put that issue front and centre, and I'm almost pleased that you asked, you put the question to me like that, and as domestic violence, because we're trying to move away from pigeonholing that type of abuse as being violent and expanding it to being domestic abuse. So it's not just and it's a complex issue. It's not just a matter of suddenly everyone's had to stay home and suddenly people started abusing their other halves. It's we saw a situation where people had their support networks taken away, their ability to get out of the house taken away, their ability to let their anger go, or whatever was triggering them off, was taken away, and it sort of put everything in that crucible. So all these cases suddenly kept popping up, and the family courts, I think probably more than any other part of the judicial system, kept being as busy as possible throughout the pandemic and having to deal with these issues, particularly where there were children involved. I think the other really significant thing that's come from this is it's really highlighted and pushed a change in how we see the abuse. I've already mentioned the sort of switching away from just focusing on violence, and how our attitude to dealing with it, and particularly how the family court's attitude to dealing with it. We've had a really significant judgment that actually sort of brought together several different cases that was released by the Court of Appeal earlier this year, that highlighted some of these problems and tried to sort of give guidance on them. And there's a recognition that actually we're still getting our heads around what abuse means, particularly in the context of something called coercive and controlling behaviour. Now, that was something that was brought in as a criminal offence before it was brought into the family side of things. So it's been around for a while, but it hasn't really been pushed and tested before the family courts in the way that we've seen in the last sort of 12 months. So we're now trying to sort of understand what that behaviour looks like. But I think more importantly than that, and you know, this is a sort of a good thing that's pushed these issues to the public eye, is that a lot of people don't understand what that abuse in itself means. I've had a lot of people coming to me saying, oh, you know, he's hit me. But then when you get down to it, you realise that actually, you know, they've been preventing them from going out, they've been controlling their finances, and it didn't even occur to them that that's abuse. And I think that process of understanding what they've been through and coming out can take some time. And again, the family sort of law approach sort of before we were focusing on this was, right, well, if you haven't mentioned it at the beginning, then it clearly wasn't an issue. And that's not quite how you should approach it. The other way that we would deal with it, we would say, right, list the allegations in what we call a Scott schedule, which is something very civil litigation. You list what's been done on what date, and the court will decide if it needs to ascertain whether it's true or not to be able to make decisions about whether someone's going to be allowed into a property or where children are going to go and how they're going to have their relationships with the parents. And one of the cases that the Court of Appeal considered was, is that an appropriate way to deal with a type of abuse that is accumulative, that is subtle, that is manipulative, and that expands over time? And the answer was no. And I'm not sure we've come out with the definitive answer, but at least we're looking at this differently so that we are recognising that these problems that aren't necessarily new are actually being dealt with in a sensitive way and in an appropriate way to provide the people who need protection with that protection.
Okay, well, thank you for that. And as lockdown eases, there's inevitably people are going to be looking at changing where they're residing, perhaps moving back towards family and friends in other countries. How are the applications for people to do that managed? What are the constraints and things people need to consider if making that kind of move?
Well, if you're looking to relocate from this jurisdiction, say you've been living here for a few years and you want to go back home, and the issue is you've got a child and you're separated. If we say you both parents or both everyone who's got parental responsibility, which usually is the parents, have to agree to that the child's habitual residence changing. And if you can't agree, then you can make an application to the court and ask for permission. Now, one of the key factors in such applications will be whether it's an appropriate time to do that. And very quickly, actually, when the pandemic hit, suddenly the considerations or the weight that was being given to different considerations in such applications changed. And I think whilst we are now looking at a world that we are moving back towards international travel being much more freed up, the weights of those considerations have changed a lot. I'll explain a bit more. So you've got the approach that the courts will have to an application to take a child to live in another country will be what is going to be in the best interests of this child. It can be quite difficult to convince a judge that a child who's doing well here, who's settled here, who's got a good relationship with both sides of the family here, should be taken away from that and taken to another country. We also have to look at the child having a meaningful relationship with both parents and assuming that that is going to be beneficial to that child. So it can be quite challenging again to sort of say, well, that relationship's going to be impacted, it's going to be changed when you take the child out of the country with the parent who stays behind. And one really, really important part of any application is what steps you're going to take to ensure that that child maintains that relationship. And that's where we start looking at the holidays, the school holidays, the dates, the flights, how that child's going to travel. Are they going to be accompanied? What are the costs of that going to be? Is it going to work? Is the parent who needs to make that happen, can they be relied upon to make that happen? And the court's going to require a certain amount of certainty to be happy to say, okay, I think you're going to make this work. I think that this child is going to have that relationship, maybe a bit different now that they're in a different country. But the pandemic took that certainty away, and it took international travel away. So you suddenly weren't able to make those arguments. And I think now that we're coming out of that, I think you've still got that sort of burning question that a lot of people are saying, well, what if there's another pandemic next year? How can you even consider letting this child leave the country? But what I say is that that argument will have certain weight. You throw into it another aspect. For example, you may have your entire support network in another country. You may have lost your job here. You may have issues that can only be resolved in the other country. You may have health issues here that have been exacerbated, particularly mental health, by the pandemic. That would mean that you as a parent aren't able to provide adequate care, aren't able to stay here, aren't able to earn money here. But you can, in, for example, going home where you've got family, you've got support, you've got somewhere to stay. And that factor will be important as well. And those are changing because of the pandemic. So overall, the court's approach to these applications hasn't changed, that it has to consider what it will be like for the child if they stay and if they go, and on balance what it thinks is going to be best. But what has changed is how the factors that the court will take into account to make that are being argued and what weight they're having. So it's certainly still possible to make those applications, but we're arguing them differently now because the world has changed.
Okay, terrific. Well, we're out of time on our discussion. We're going to cut the